It's Tuesday, May 7th, 2019. It's a regular meeting of the Eugene Planning Commission. I'm going to start with public comment. So this is, because it's a regular meeting, it's Planning Commission reserves 10 minutes at the beginning of the meeting for public comment, except for items scheduled for public hearing. And we have our second agenda item is a public hearing. So reserve your public comments for that public hearing. So right now it's just public comments that's not relevant to the hearing that we're hearing tonight or future hearings. I think the two people that we have green slips both have to do with the public hearing. Is there anyone else out there that has something else to say that's not related to the public hearing? Okay, so we'll move to, before we move to agenda item B, I just want to have, Robin has one piece from staff as a reminder.
Yeah, thanks. Just a quick follow-up on the email about this would be the June 4th deliberation date. So I think that was the second deliberation date for the topic that we're discussing at the public hearing tonight. Just kind of a quorum advisory. I think there's 4 commissioners left, and we really need you here. And if there's any reason that you foresee coming up that you might not be able to, please let us know as soon as possible. Otherwise, we're counting on you. So thanks for that. And I just want to point out that Commissioner Edwards is on the phone. For everybody in the room, if you hear a disembodied voice coming from the table, that
hopefully they're not disembodied. Well, maybe.
I don't see your body, so I just hear a voice.
Yeah.
So that's it. Thank you.
Okay, so the next agenda item is a public hearing for downtown Riverfront adoption package. And I want to disclose something is that TBG Architects and Planners, the architectural and planning firm that I work for, is part of the team representing the applicant on the downtown Riverfront Tentative Subdivision application, ST 1903. The tentative subdivision application is part of a package of a downtown Riverfront land use application that will be considered by the Planning Commission. Therefore, pursuant to ORS 244.120, Eugene Code Sections 2.333 and 9.7065 in the bylaws of the Eugene Planning Commission, I'm declaring an actual conflict of interest with respect to the downtown Riverfront tentative subdivision application, and I will not participate in any discussion or decisions by the Planning Commission regarding the downtown Riverfront application package. So I don't know if I need to repeat that again. So I'm going to pass the meeting over to John Borofsky, who will
adjourn it immediately. No.
Yeah. So who will basically be in charge of the public hearing. And do you want me to stay to dismiss my, no?
Yep.
So thank you. Good luck.
Okay, I'm going to open the public hearing. Good evening. Thanks you all for coming. Tonight we'll be holding a public hearing of the Eugene Planning Commission on a package of city-initiated land use application for the downtown Riverfront. My name is John Borofsky. I'm sitting in tonight as acting chair of the Eugene Planning Commission. To start, I'd like each of the commissioners to introduce themselves.
Hi, my name's Lisa Fragola.
Good evening. My name is Chris Ramey.
Good evening. My name is Stephen Baker.
That leaves you, Tiffany.
All right. Good evening. This is Tiffany Edwards.
Also, we are joined at the table by some staff. Would staff please introduce yourself?
My name is Robin Hostick. I'm Planning Director.
Gabe Flock, Senior Planner with the city's Planning and Development Department.
Lauren Summers, Assistant City Attorney.
And we also have other staff in the room that may be coming up to join us at some point if needed. I'd like to take a moment to explain who the Planning Commission is and our role. We're unpaid volunteers appointed by the Eugene City Council to 4-year terms on the commission. This commission often makes recommendations to the City Council on legislative matters such as plan amendments and adoption of new land use regulations. We also hear appeals of decisions made by a city hearings official. Tonight is a hearing for a site-specific set of city-initiated land use applications, which staff will briefly summarize before we start taking testimony. The Planning Commission's role in this process is to make a recommendation to the Eugene City Council on whether to approve approve with modifications, or deny the applications. Some of the terms we have to use are legalistic, so I'll try to explain the requirements in plain English as best I can. Since this is a hearing, since this hearing is for site-specific set of land use applications, there are a unique process which we are legally required to follow. The decision-making process on this type of request is considered quasi-judicial, so we will be using a quasi-judicial format for this hearing. This means we have a certain order of speakers that we need to follow, and there are certain rules or criteria that our decisions must be based upon. Before we begin, the Eugene Code also requires that Planning Commission disclose any conflicts of interest, ex parte contacts, biases, abstentions, or abstentions. In a quasi-judicial proceeding, the parties are entitled to an impartial or neutral decision maker. To ensure this fair consideration, the Eugene Code and the Planning Commission's rules attempt to limit ex parte contacts or communications between a party and the decision makers outside the public hearing process. Each planning commissioner must disclose and describe the substance of any communication they have had about this application outside of the public process. The Planning Commission must also disclose any conflicts of interest, that is, whether the decision they are about to make could or would result in personal financial gain to themselves, their businesses, or a member of their household. Finally, a Planning Commissioner cannot participate if he or she is biased, that is, for whatever reason, he or she is incapable of making objective decisions on these applications. At this time, do any commissioners have anything to disclose? Commissioner
Hi, this is Commissioner Edwards. I had put this on the record previously, but I do need to declare a potential conflict of interest, if you'd like me to go ahead and read that.
Yes.
Okay. So the Planning Commission will consider a package of land use applications related to a proposed redevelopment of the downtown riverfront. My employer, the Eugene Chamber of Commerce, has expressed support for the proposed redevelopment. I'm not aware of any financial benefit or detriment to the chamber that could result from my actions or recommendations as a planning commissioner related to the downtown riverfront application package. However, in an abundance of caution and pursuant to ORS 244.120, Eugene Code Sections 2.333 and 9.7065, and the bylaws of the Eugene Planning Commission, I am declaring a potential conflict of interest with respect to the proposed downtown riverfront package. It is possible that the redevelopment of the riverfront could bring new business to town, which could financially benefit the Chamber of Commerce. I understand that after declaring this potential conflict of interest, I may still participate in the deliberations and discussion of the Planning Commission. I understand my responsibility in a quasi-judicial setting, and I take it seriously that I need to remain unbiased during this process. I have the ability to set aside any personal views and to evaluate the downtown riverfront application package based solely on the evidence and argument in the record and the applicable approval criteria.
Thank you. Other planning commissioners? I would just like to state that I have attended several meetings where the downtown riverfront has been discussed. I gave testimony to the river guides regarding the funding of some of the park that is being proposed for this area, as well as other uses of the riverfront urban renewal area budgetary things. And I've also attended city council meetings where these things were talked about, but I don't believe that has biased me in any way, and I believe I can render a fair decision. Anybody else? Okay. Does anyone in the audience or member of the commission wish to challenge the impartiality of any of the planning commissioners? Seeing none. The purpose of this hearing is to receive relevant.
Commissioner Borowski, to interrupt you. Can you?
Oh, the if ex parte?
Yes.
Excuse me, I skipped over one because I thought it was only relevant if somebody objected. But if ex parte contacts are disclosed, state any person during his or her testimony has the right to rebut the substance of an ex parte communication just disclosed.
Great.
That what you want? Okay. All right, sorry. After disclosures, that's what we just did. The purpose of this hearing is to receive relevant testimony on the request before us. I want to remind everyone that your testimony should be directed towards the approval criteria that you believe applies to these applications. We ask for you to frame your testimony in terms of the applicable approval criteria because the Eugene Code requires that our recommendations be based on the approval criteria. For reference, the approval criteria are listed in the application narrative that was prepared as part of the staff report. Those wishing to speak during the public hearing should have filled out and submitted a completed requested to speak form to staff. If you wish to speak and you have not already done so, please submit one of these. And there's still plenty of time to do that. Once the public hearing is open, speakers will be called in the following order. 1, those in support. 2, those with a neutral position. And 3, those opposed. I know commissioners have asked for more clarity on when it is appropriate to ask questions. And staff has suggested that if you have questions about someone's testimony, you should ask those questions following that individual's testimony. Following the conclusion of all public testimony, staff will also have a chance to respond to the public testimony presented, and commissioners will have the opportunity to ask staff additional questions. I'm supposed to remind everyone that the failure to raise an issue with sufficient specificity to allow the Planning Commission and parties to respond will preclude future appeals on that issue. In other words, now is your opportunity to raise issues as clearly as you can so that the city and other parties can address them. Just a reminder, the Planning Commission will not make a final recommendation on these applications. We will make a recommendation to the City Council, who will hold their own public hearing before making a final decision. We also won't be making our final decision tonight. We will have future meetings on June 3rd and 4th and possibly June 11th if needed to deliberate before we make our final recommendations. Now it is time for staff to give us a short presentation.
Thank you. So as you may recall, staff was here on April 22nd to provide an overview of the project and all the different applications involved. But I thought tonight it would be helpful for the audience and just as a refresher to cover some of the highlights. So I will walk through a number of slides that you've seen before. But again, I think it helps us focus a little bit on some of the key changes that are proposed in this package. And of course, you know, as you know by now, the application materials are extensive. And so we provided you with all that information to the best of our ability. And as Chair Borofsky mentioned, as quasi-judicial site-specific applications, your decision will need to be based on evidence in the record and based on the approval criteria for each application type. And there are multiple applications included. And so we will have plenty of time at deliberation meetings on the 3rd and 4th of June and potentially the 11th if we need it to really wade through things in more detail. My hope is tonight, too, that we'll have an opportunity for commissioners to ask questions that might help staff to prepare and respond to some of those questions or concerns, for that matter, in advance of the meeting. So that we're off to a good start on the 3rd. So assuming there's time for that tonight, we would like to engage in that. I think this illustrative concept plan is helpful to start with. It really helps to see what could result in terms of the regulatory changes and the overall development plan that we've been working on. It's helped tremendously as the staff team and a variety of consultants working on the project have looked at what types of changes are necessary to the existing, what we call a master plan for the former eWeb site. As some of you may recall, we went through an extensive adoption process in 2013, and we do have an existing special area zone that regulates development of the property. But now, with the city's partnership with the developer and with more information and design choices that have been made about how to make this project successful, we realize there are quite a few changes to the code and to other regulatory components that I'll talk about in a minute. And so just to get specific, this list of applications is what's included in this Type 5 application process. And I think, again, it's important to remember the city elected to review these and process these applications concurrently for good reason, not just based on the benefit or efficiency of time in moving forward, but also I think it affords a greater degree of public participation, opportunity for public comment, where some of the what I'd consider lower level application types like zone changes, Greenway permit, tentative subdivision, and standards review would not normally be coming in front of you. But I think the benefit is to see, the full gamut of policy choices to be made, new code, and all of the other regulatory approvals that are necessary to essentially make this thing permit ready, right? So we get to see the interconnected parts as a whole and look at it really comprehensively. So again, looking at a set of comparisons here just to highlight some of the changes. This is an example that shows on the left the existing regulating plan in the code for the site. And on the right is the revised regulating plan that's in the draft code. And you'll see that it includes a different street configuration, a reconfiguration of the park property, and it locates the zoning subdistricts. And I think it's important to recognize that, with the change in the street layout, what we've done is really paid special attention to where it makes appropriate in the revised code to have certain overlay requirements that help to activate the key street frontages. Moving on to the height regulating plan, again, you can see existing and proposed. And again, special attention's been given to customized height standards. And in the code, you'll see form-based code graphics that help to illustrate what the sort of maximum building envelope is for each of these height districts. So each lettered area has a different height standard and certain requirements that go along with it, with the idea that the height essentially steps down as you move toward the river. Here, again, is a comparison of existing and proposed. The street network diagram shows street typologies that are numbered, and so similar to the height regulating plan, we have customized street design requirements that are attached to each type. And as you walk through the code, I'd encourage you to look at those cross sections and other graphic depictions that help to understand the kind of choices we're making about key street designs and particular locations. Here, again, you can see the existing park regulating plan, and on the right, the proposed new configuration. And it shows a fairly, I'd say, detailed set of elements. It's not the final design, but it does show what I would say are required features of the park, including a new multi-use riverfront path that's being relocated from its current location, and different areas for the upland urban plaza area interior to the site, and riparian enhancement areas along the riverbank as well. Here is a map showing the existing downtown traffic impact analysis exempt area. And this was, I believe, established a number of years ago related to, an understanding that our downtown gridded street system is essentially fully built out. And so there was a policy choice made not to require what we call a TIA, an individual land use application for each development that triggers over 100 new peak hour vehicle trips. At that time, and during the adoption of the exempt area, we looked at the eWeb property, and in the midst of that adoption process, we recognized we didn't have certainty about exactly how and not nearly as much control now owning the property as to what exact sort of transportation improvements might be necessary. And so there was a reluctance to exempt it from the requirement. Now with the support of city's engineer and his recommendation and looking at city's heavy involvement in the infrastructure decisions being made and the layout of streets and really knowing the essential street improvements that we're going to need to make to accommodate this development, what this proposes is to exempt the subject properties along the riverfront, as well as a few additional parcels that are being added north of 4th Avenue. This is, I think, a good reminder of the refinement plan amendments included in the package. One is to repeal what is known as the Eugene Downtown Riverfront Specific Area Plan, and this was adopted as sort of an underlayment or a basis that led to the specific area zone that exists today. And we recognize as we embarked on this process that there were really only a few regulatory components that remained in that plan that were linked to the code requirements. So, for example, the requirement for view corridors, a plants list specific to the park, and some policies related to design review were still included in that plan. And so what we've done is essentially extracted those key regulatory elements and incorporated them into the code to the best of our ability so that, one, it's more efficient, and you look at the special area zone, you have everything you need. You don't have to cross-reference multiple documents. And our hope is that there'll be a recognition that we've carried forward, albeit with a different design, the sort of key underlying intent of that plan. We do recognize that to keep it would actually create confusion in terms of a variety of different diagrams and things that depict the original design as compared to what it is now. And in terms of the Whitaker plan, what we're proposing is to amend the specific policy that calls for site review. And so there are some properties north of 4th Avenue that have the existing site review overlay. And as we talk about the zone change, we'll talk about the removal of site review. But in order to do that, and I think this is an example of how these things are interconnected, in order to remove the site review overlay from those properties, the policy needs to be changed. So here looking at the zone change maps, it's important to recognize most of the property is already zoned with the downtown riverfront special area zone and the water resources overlay, which is the sort of cross-hatching. Up here in the northwest corner are properties that are zoned special Whitaker. And so it is a similar, well, I should say it's a mixed use zone that implements that plan's designation for mixed uses. But what we are proposing to do for continuity and a variety of other reasons is to rezone properties in that area to the downtown riverfront special area zone. There are also a couple of parcels we recognize that were really sort of overlooked, if you will, or weren't included in the footprint of property in the original adoption. One is zone industrial and one is public land. And we thought that this was a good opportunity to clean that up, so to speak. And for continuity, this will be regulated as part of the park And so it made sense to include that in the zone change. Here is, I think, an important map that's worth pointing out. And this was actually part of the adoption originally in 2013. I think an important takeaway is the fact that the site is largely paved, and most of the property is exempt from what would be a 100-foot setback from the top of bank. And so right now it's essentially paved right up to the edge of the riverbank. And the colored areas there reflect what remaining regulated area there is under what we call the water resource overlay zone. That overlay zone implements the state's Goal 5 protections locally, and it has some special regulations in our code that this project is subject to, and we'll talk about that in a minute as well. Another really important part of this is to recognize that most, I'd say, or the majority of the property is inside this green line, which represents the Willamette River Greenway boundary. So east of the viaduct for Ferry Street Bridge there and the railroad, this property is already approved with a Willamette Greenway permit, such that any development that occurs under the downtown special area zone does not need their own Willamette River Greenway permit. So we wouldn't incrementally do this Greenway permitting process on a project-by-project basis. The idea is that with this package, we're essentially renewing that Greenway permit, and think we need to do that to the extent that we are revising the height districts, the street layout, a variety of changes that cause us to need to renew that. Here we have just one of the plan sheets from the tentative subdivision, and essentially it's a 17-lot subdivision. It's not the entire subject property, but it's an important step in the direction of creating the lots for redevelopment on the site and all of the key rights-of-way, with the idea being that, and close attention by staff to make sure that it is consistent with the revised code. It also helps to more precisely locate. I mean, it might be hard to see here, but there are some crosshatched areas along key street frontages that are intended to reflect where those special overlays exist along certain parcel frontages. And here is another plan sheet showing the standards review application. And just as a reminder that what this package includes is approval for a relatively specific park design. Certainly there's some flexibility in terms of planting and exactly how things get implemented on the ground, but this is a necessary regulatory step in order for the city to pursue and construct the new Riverfront Park. So here, again, is the timeline. We had an overview a couple weeks back. On May 7th here, we are having the public hearing. We have deliberations scheduled for 3 different meetings leading up to your recommendation. And then the hope is to have council hold their own public hearing. And as a reminder, your role here is to provide a formal recommendation to council. And then they will have their own public hearing process. So it's an evidentiary hearing. There'll be plenty of opportunity for folks to participate at that level too, including any new evidence at the council level. The goal would be to have council act, hopefully, or at least hold the public hearing before their break sometime this summer in July. I think I'll stop with that, and just as a reminder, we'll keep this up on the screen in terms of the order of speakers. There are a few things I placed at your spots that I want to mention just for the record. One is just a helpful handout for you and anyone else who might be interested that provides a little description and kind of an overview of what these applications include. I've given you a copy of a Register Guard article related to the downtown Riverfront property and some demolition that started on the site. And in the realm of this conversation about ex parte contacts, this is the kind of thing, if you come across articles or if staff does, we'd like to know about it. We'd like for you to forward that so that we can kind of keep abreast of whatever additional information you might be looking at as part of the process. And to date, I would note we have given you copies of 2 different emails submitted into the record, and so we would consider this written public testimony. One of them I think I would generally characterize as an interest in having more parking downtown. The other, I think most importantly, is an email from Charles Biggs that requests for the record to be held open. So we were wondering whether that request might come, and under state law, based on that request, we are obligated to hold the record open and for at least 7 days. And we'll talk a little bit about that at the end of the hearing. I think we can turn it. Oh, question.
Yeah, I just had a question about notice. So given that this is a substantial package and a lot of things are affected, you notify property owners within, was it 150 feet or 300 feet or?
Actually, we noticed according to the Type 5 procedures, but we went beyond that. And so just to touch on it, one of the things that's not required for a Type 5 process is a certain radius of owners and occupants to be notified. But because this application includes a tentative subdivision, a Greenway permit, and standards review, we elected to go above and beyond and include a radius of 500 feet. So all owners and occupants within 500 feet would have received the notice of this public hearing. Of course, we provided notice to the state's Department of Land Conservation and Development. We provided notice to each of the other local jurisdictions, Lane County and Springfield. We have noticed all of the officially recognized neighborhood associations within the city. We provided what I would call a legal ad, which is an advertisement in the paper noting the time and date of the public hearing tonight. I'm trying to think if we missed, what's that? And yes, thank you. And signage in, I think, about 8 locations around the site, including the bike path and key street frontages.
Well, one follow-up question on that. Since there are some historic structures directly across the street from the proposed plan area, was the Eugene Historic Review Board were they members notified, or was the State Historic Preservation Office notified because there were some state registered structures there?
It's a good question. We did not reach out to each individual board member, but I would note that you, Commissioner Baker, do serve as their subcommittee representative. And the important point I want to make is that we've been working closely with the state's Historic Preservation Office for many years on the necessary clearances and decisions to be made about agreements for mitigation of the loss of any potentially historic properties. We have documentation of all the necessary clearances for any of the buildings on the site that are being demolished. I think, and I don't have the precise details, but I think there were at least a couple buildings that were determined not to be eligible as historic properties. And I think another important point, although it's not part of this regulatory package, is to recognize that the city's intent with redevelopment of the steam plant is ultimately and hopefully to have it designated on the National Register, which it is not currently. Is that helpful?
Well, it's a quandary because I was told by our legal staff not to have any discussions with this, so I didn't feel like it was possible for me to mention to to email the Historic Review Board members that this hearing was coming up. So, and maybe legal would better clarify for me what my position is, but I felt that I couldn't speak about this to anyone, even to notify them that there was a hearing coming up, given what we were told in our email. So it's a kind of a catch-22. Theoretically, I should have been able to I would have normally channeled this information to that commission, but I didn't because I was told something different.
Of course, Lauren, feel free to correct me if I'm wrong, but I don't think there's anything inappropriate about you reaching out to board members to encourage their participation in this public process. I mean, expressing your opinion about it or what they ought to do or not do in response to it is maybe another thing, but we would encourage their participation. And I think the benefit of having an open record period established here will mean that you can do that and that they can submit at least written testimony following the hearing process. So.
Yep, I agree with Gabe, and also, so open record for written submissions to the Planning Commission, and then anyone, including the Historic Review Board, would have the opportunity to appear at public hearing in front of the City Council and submit testimony to them as well.
Okay. Thank you.
All right. Without any further questions, I am going to call the open the public hearing. And now I'd like to open the public hearing of the Eugene Planning Commission. If you wish to speak and have not already filled out a green request to speak form, please do so and bring it forward to staff. Please state your name, address before beginning your testimony. We encourage you to submit any written testimony you may have as well. So we will go in order of those in favor, those neutral, those opposed. And I have two people who've submitted forms, one in favor and one neutral. So we'll start with Jim Atkins. And if you want to just come up to the table, grab a microphone and let us know what you'd like us to say or hear.
Good evening, commissioners and staff. My name is Jim Atkins with Williams & Dame. I'm partnered with Williams & Dame. I'd like to introduce my partner, Dyke Dame, who's here with me as well. We're here to speak with you this evening specifically about the parcels north of 4th Avenue. Having spoken with staff over the last month, recognized the significance of the neighborhood, the historical neighborhood to the north, we've proposed a minor modification to the code amendments before you to recognize a potential setback from two of those historic buildings, the former Bray grocery store, which dates to 1924, and the Ham House, which dates to the 1890s. What would help in this is to pass this around to all of you and share this. So I'll just pass these down. I'll save one for myself. Pass them around. Thank you. And Gabe, what would be helpful to show is to go back one of the site maps, if you wouldn't mind.
Glad to. Let me know what you think is most useful.
Just that illustrative concept drawing.
Yeah. Yeah.
There, yeah. So I'll let you all get oriented first.
There is a laser pointer you can use here.
Oh, okay. There might have been a couple extras in the package there. So the area we're speaking about, if you look here at the screen, are these approximately 50,000 square feet that is north of 4th Avenue, extending between Mill and High. So these right here are the properties, these properties are the properties that are in the disposition and development agreement, where we have entered into a disposition and development agreement with the city. This property right here is not. This property is owned by a gentleman by the name of Mr. Stuart Davis. He's owned it for some time, has an office building on the site. We're here, we have verbally spoke with him and here representing him to some extent. We have a sort of this verbal authorization to speak about this matter. I can't really sit here and negotiate on his behalf, but I can simply say we have been in contact with Mr. Davis. We've had a meeting with him. We have shared with him what is going on with the code amendments and why, and the height and the setback issues. And we've had discussions about the proximity to the historic neighborhood to the north. But so speaking about this area right here, though, sort of comprehensively, that's what these documents in front of you attempt to do. So I'd like to walk you through these and sort of explain page by page what we're proposing. Page 1, the first page in your packet, is a illustration of what would be allowed under the current zoning. And Gabe, if you wouldn't mind helping me, the current zoning is referred to the Whitaker
Special area zone.
Special Area Zone, thank you. So the Whitaker Special Area Zone would allow buildings up to 4 stories above grade adjacent to that alley, which is adjacent to the historic building. So if you, the 2 buildings we're speaking about would be this building being here, the historic Bray grocery store, and this being the Ham House. This is a non-historic building, A1 auto glass. And then the property parcel 1, the Davis property, is adjacent to the Ham House and the Bray grocery store, just to kind of orient everybody. So according to the current zoning would allow buildings up to 4 stories from the grade at the Ham House. That would put you at elevations 476 above parcel 2. You can see above parcel 2 where it says 476, and 483 above parcel 1. And then it doesn't have any concept of setbacks included in the current zone. So property owners would be allowed to build up exactly to that property line, which is adjacent to an alley, which is an alley of 14 feet in width, which then the Ham House and the Bray House are set back a few feet from that property line. The second page illustrates what that looks like in cross-section. So if you back on the first page, we had a cross-section labeled AA, so a line drawn through right here, line drawn through the Ham House. So now looking at it as you were looking up the alley. So if you go to page 2, let you all get to page 2. That condition, that shows the 14-foot wide alley. So that would be where the building would be built under current zoning, up to elevation 483. So now page 3, so under the proposed zoning of extending the riverfront development to encompass this block here and the blocks north of 4th, but this includes the property of Mr. Davis. We've laid out how 2 buildings may lay out on the site with what would be the new height designation. The new height designation would allow construction up to the Skinner Butte height limit of 500 feet above mean sea level, or approximately 20 feet above the current height limit, just because they're measured in 2 different ways. The current height limit's measured from the existing grade. The proposed height limit is measured from an arbitrary line in the sky at 500-foot mean sea level elevation. So this diagram here shows how 2 structures might be laid out on the site that would allow for 2 buildings, each of 6 stories tall, from that same alley. And then again, we've drawn the cross-section line through here at the Ham House property. And we've illustrated graphically here that there would be a setback from any building mass. We would come up 15 feet, so there'd be 1 floor built adjacent to the alley. That would be 15 feet high, and that would probably encompass parking with some type of amenity deck built on top of it. And then the mass of the structure would be set back 20 feet. So the red line drawn there would represent the envelope where the mass of that building could be placed on top of a 15-foot high podium. And then turning to page 4 shows a cross-section of how that might look relative to the alley and the Ham House to the north. So what this reflects is that 15-foot alley. And then here in this diagram, we have laid out the building so that the mass of it would be up against 4th, but we don't know enough today based on how these 2 lots may lay out to say emphatically it would fit here or it could fit here. What we can say is that we think a 20-foot setback treats these 2 historic areas, these 2 historic buildings, by pulling that mass back and creating a little bit of open space. And then the other addition we included here was showing some type of activation here at this corner of what is probably the garage. But why we called it a bicycle hub, it at least allows for windows, it allows for doors, it allows for some in and out activity. And then what that starts to look like in plan view is the final page. So page 5 kind of shows how this might lay out in plan view. And it also starts to represent how these 2 unimproved alleys, the one that runs east-west from High Street to Mill Street, and the one running from 4th Avenue north up to intersecting that alley, that east-west alley, could be improved as either pedestrian access ways and/or what we've termed in other developments in South Waterfront, universal access ways. So they would serve a few purposes. They would be more pedestrian-oriented, but would allow for potential vehicular movement. So, for instance, the property owner to the north of Parcel 2, that is the Swahili storage building, and they often have trucks going in and out, so we'd have to accommodate those trucks. These two, the two historic buildings here have been divvied up into a number of apartments. I think there's approximately 7 apartment units in the Ham House and about the same number in the Bray House. They park in this area, so you'd have to have some allowance for vehicular movements on that alley. The Parcel 2 parking garage would probably access off the alley. So by pulling the buildings back, so again, the 20-foot setback line, we pulled that mass back, and trying to activate this corner right here with a quasi-public use in the sense that there's a lot of activity coming in and out, and at least there's some windows there, and it's not just a blank wall. This would be the entrance if you lived in this building and you wanted to come in and wash your bike. We've done this in other projects. We built a bike cleaning station or bike maintenance station. So this is where if you came back from a bike ride, this is the entrance that you would come into. It helps to open up the area around the Ham House. The Ham House's historic front door is facing the alley. So it's kind of been lost over time, and what we're trying to do is to pull that building back a little, trying to create a little activity on the corner of what would be the back side of this building, and really recreate what is a front door now on an improved universal access way. So after a lot of discussion with staff, we met with Mr. Dowdy and with Gabe and had discussions about what was the appropriate setback, and this was a proposal that we both thought recognized the historic significance of the properties immediately to the north, but also allowed enough flexibility that we could ultimately develop the kind of vibrant, mixed-use, dense urban neighborhood that we're trying to create in all of this. So this is not an amendment that's yet included in the code, but over the last few weeks, I believe it was Commissioner Baker, I think you raised the issue at the first meeting. We looked at that, it made some sense, and we took a look at it and tried to think, well, what could we do inside the code that would recognize those concerns? So happy to answer any questions if that wasn't at all clear.
Commissioner Ramey?
So isn't this a historic district?
It is.
Where's the boundary for that?
We do have a copy of it in the record, and
I got it
it
in my
might,
briefcase if you don't.
I think I might actually have it available here. It might take me a moment to find it. Can I have the mouse?
Oh, yeah.
It was in the first packet we got lost.
It'll just take a sec here.
On the flash drive,
Yeah.
the big dot. You have the flash.
Because there's 2 lines there. There's a district and the,
And my second question is, I think the house that's to the east of the auto, I think that might have some historic status, be north of what you call the Ham House.
I think it's important to recognize that essentially the footprint of the district is regulated.
District is one thing, but the structures within
Yeah,
the district.
of course.
That's
They,
what
they,
I can't remember from my turn on the historic review board, which is like a million years ago. But I think that house might be
which house, I'm sorry, Commissioner Ramey.
underneath the tree
No, there's no home there.
right here.
No, there's
That
no,
house is gone?
yes, yeah,
Ah.
there may have been a structure there, but no, there's no home.
getting the name of it, there was a demolition actually that.
Oh, okay.
It was so dilapidated, it was.
Yeah,
it
it
was
predated
rotting
our involvement in the, I
and
wasn't aware there was a
became a
structure there.
hazard. So here is the boundary of the, and I believe this is a combined boundary. You know, they're not exactly identical, but there's a National Register district and an overlapping city historic district. But this should reflect the outer boundary of both districts combined.
But if you go back up to 4th, Gabe, I think we're,
Yeah, so
so what we're looking at and parcels that we're speaking about.
they're over here.
Are these right here. So
Sorry.
this is the Davis parcel, and then this is the EWIP, former EWIP property that is part of the transaction.
Yeah.
And then here's the Ham House and the former Bray grocery store and the A1 Auto
And the
Glass.
house that's not there anymore.
And the house that's not there anymore
Letter Y.
must have been right there. Yep.
And across the street are 2 historic. National Register houses.
Which is,
Yes, correct. Those houses across, High, yeah, of course, there's several homes there that are,
And I think a related point, just to touch on it here, is that when you look at the policy in the Whitaker Plan that calls for site review, it has to do with properties that are adjacent across, or in this case, kitty corner to a historic district.
Right.
Yeah, so, thank you for bringing that up. It's good to look at that.
Commissioner Fragola.
I'm curious, I see the two parcels here. What's the shadow box? Is that potential future
Potentially,
development?
that's what would be allowed under the current zoning that would remain in place after all this work. And I thought it was useful to show that because there's only a warehouse there and an unimproved lot, so it's likely going to be suitable for development. And I think it's important to look at it sort of in the context of what would happen there in the future.
And I would just add that while it is reflective of what would be the maximum allowed building envelope with the 45-foot height limit in the Whitaker Special Area Zone, well, I think, if it's actually not within a historic district,
not.
then it wouldn't be regulated in the same way as other historic properties would, which just for purposes of, educating everyone, I mean, the local code requires a historic alteration for sort of essentially, any significant changes to any of those historic properties, and it has its own review process and a land use decision associated with it. So, for example, the Bray House and the Ham House, I believe, would be subject to that.
So then this future potential development would also be susceptible to the other setbacks that you're discussing for these other two parcels, or are these setbacks only specifically for these two parcels?
The only setback we've proposed is for parcel 1 because of its adjacency to the historic structures immediately to the north. Because parcel 2 does not immediately abut the historic neighborhood, and nor does it have any historic structures to its north. I'm talking about this parcel 2 and this land. We did not propose any setbacks from this site, only here to set back with the structure at least 20 feet from this alley to open up some space next to these two. And we didn't propose anything here. All we showed that shadow box for was just for illustration of what could be built there someday.
someday, but not as part of this. This is not part.
Are you finished?
Yeah.
Okay. Chris, you have another one?
I greatly appreciate you going to the proactive work to figure this out, and 20 feet seems like a reasonable setback. But just so I'm clear about it, you could actually build this L over here.
Yes.
That could go.
It could.
You illustrated it.
Correct. And we haven't done it, the reason for the, I'm sorry, go ahead with your question.
I know why.
Yeah.
I just want to be, because as I go through the rest of this code, I see illustrations like this, but I want to understand, you could actually build that whole thing, not that you would, but the way the code's written, that would be allowed.
You would be able to build within that setback box, and you could put
Right.
the structure, and the structure could be an L-shaped, it could be a T-shaped, it could be a U-shaped, it could fit in there any way, and that's really the purpose of, we just don't exactly know what's the best fit for that lot yet.
I just want to be sure I understood that.
Mr. Baker?
I wanted to thank you for bringing this forward, because I think at least this was one of my concerns was,
I wasn't here at the last meeting, but I did watch it on
yeah, no,
simulcast.
so it's one of my concerns because of the historic structure. So I do appreciate this, and we'll probably, obviously we'll review this when we review all the testimony, but I really appreciate you making this suggested code modification or whatever.
Sure.
Or proposal modification.
All right. I've just got one little comment. I guess I would hope that staff would bring back some sort of language that we could review if there is going to be some sort of a modification to the code language that we can review during our deliberations.
I didn't want to come out prematurely and suggest any particular outcome, but with this evidence in the record and with, I think, what are relatively clear setbacks and height limits associated with that one property line, basically. It's a fairly surgical change and something that we'll have to figure out and bring back. But with the open record period, I think we'll have time to be able to propose an amendment, or should I say a revised standard that could be embedded in the draft code that's specific to this interface right here on this parcel. Haven't figured out exactly the best way to do that, but we will. Glad to.
And we'll get into those other questions as we, do you have another question for the,
I have a question for,
if it's for staff, we can wait. If it's for the person who provided testimony, that's who the questions are.
well, that's fine. I just was curious for the drawing one, for those elevations, are those two properties pretty level? So in other words, there's not much of a gradation across the property?
No, they actually have quite a bit of slope, and, sorry, if I explain it from here. This would be the high side. It's at about elevation 430, and there's approximately 10 to 12 feet of fall from this alley down to 4th Avenue, so everything's sloping this way. Does that help?
Yeah, that does help.
And so we envision those buildings as kind of daylight basement buildings that would have another floor, but it would only be visible from the 4th Avenue side.
Okay. Any other questions for Mr. Atkins? Okay, thank you for your.
Thank you all, Commissioners.
Nobody else has signed up for in favor, so now we're going to move on to the neutral, and I have Jackson Kellogg.
Thank you. I'm Jackson Kellogg. My address is 2485 Pioneer Pike, and I'm a runner. I run by the river every day, and I'm concerned about the height of the buildings that are being proposed. If you run by the river every day in the winter, the EWEB steam plant casts a long shadow over that path, and it's pretty icy, and on some days the ice actually never melts. So I think the park maybe should be wider and the building should be shorter. And that's my concern.
Okay. All right. Any questions from the commission to Mr. Kellogg? Yes.
You mentioned that there's an example building that you were concerned about, the steam plant.
I'm glad the steam plant is going to be preserved. I'm just using it as an example.
We're just trying to get an idea of what the height of your concern is what I'm getting at. So that's a good example.
Yeah, exactly. That building does cast a pretty long shadow over the path.
And that's quite close to the running path at that point?
It's very close to the running path, yeah.
Just so we could take that geometry and
Yeah,
and review, because it may be a problem there, but it may not be a problem in some other parts of the site, so.
my guess is that shadow would actually go all the way to the river in the winter.
And then, does the headquarters building create the same problem? It's the one that's up here?
No, it doesn't, but it's oriented in a different way. So it's the part of the UF building is north facing that causes the shadow.
Any other questions? All right, thank you.
Okay, thank you.
I'm going to put it out one more time. Is there anybody else that would wish to give public testimony at this time? I don't have any more green slips. Seeing none, let me go back to my script. Okay, so now we have, do any commissioners have questions of staff? Yes, so let's just start with Stephen and come this way.
Okay, well, one thing in reviewing the record and looking at some of the drawings, a number of the before and after drawings sort of use the same designation, A and A, but they have different meanings sometimes in the.
So you must be referring specifically to the height regulating plan.
Right.
Should I pull it up?
Yeah, so what I was just going to suggest, because it wasn't very clear about what happens.
Forgive me, I will, in a moment, provide some explanation about what that is. I can also pull up the draft code, which shows the graphics, which might be helpful, but here, it sounds like you're referring to the differences between
That,
the lettered designations, and yes, I think A in particular, I think as Mr. Atkins was pointing out, includes a difference in actual height allowance and increasing that height allowance from what the existing code currently allows. So going from 45 feet to something more like 65 to 70, depending on the grade change. But still respects what is known as the Skinner Butte height limitation for an area that wraps around essentially the south side of the butte, and limits building height to a maximum of 500 feet above mean sea level.
right, but what I was getting at is we're maybe used to looking at this kind of stuff, but to a lot of other people, they may not know the distinction, so it would be helpful if you could produce a drawing like that one you have there.
Well, let's pull up the code graphic, because it is in fact intended to provide a visual representation of those differences and
Right.
see if it's a good starting point.
I think it was useful, but the point is, I think it would be helpful if you had heights. In other words, a plan drawing that showed the maximum buildable heights and another before and after, and that would be easier for people to just zone in on areas that they may have a concern about.
Are you talking about renderings or
No,
or
just
text or?
Just if you had the drawing instead of A, you duplicated the drawing and said this one is 45 and this one is 70, then it would be clear to the public, what is going on, rather than having to go to a set of drawings and try to figure out here's the old A rules, here's the new A rules, there are all kinds of setback and other kind of distinctions. Just a way of communicating, this is complicated information, and communicating it to the public, because you have another set of public hearings after our deliberations as well.
All right, Commissioner Ramey.
Okay, I have a couple pages. I don't know how you want to do this.
Commissioner Fragola. I'll get back to you, Commissioner Ramey.
If I may, we do have other staff and some of our expert folks have been involved with park design, some of the other design choices and things like that. I'm here to help provide our best response we can tonight. If they're relatively simple, straightforward questions that we can deal with readily, then we'd like to do that tonight. If there are things that we ought to bring back or feel like, hey, our response wasn't, maybe it requires some further thought, we can bring that back for deliberation. So,
Yeah, we'll go through as many as we can. And I've got a few as well.
7:30.
Until it's 7:30.
That's
Yeah.
not going till like 8:30.
It can go till whenever. I've got it recording. Commissioner Fragola.
So are we going to hear more information before our questions, or are we going to start with questions?
Questions?
Okay, great. So I do have some concerns about the frontages, like the setbacks of the buildings. I think that was highlighted in the letter that you emailed that you gave us as part of the public records today. And, I think about some of the buildings around town that I feel like I'm in a canyon when I walk by. The Olive Street buildings downtown, the developments on Franklin Boulevard that it's like you step out the door and you almost step into the street. So I'm curious, like if you could give me a comparison, what are the setbacks going to be like in this development? Because we want this to be a focal point in the city where people come and enjoy and experience and participate. I know people are going to also be living there, but can you give me a comparison so that I have a reference point, what the setbacks are going to be like within the code here compared to some of these other structures that have been developed in the city?
and so you're looking for a comparison to buildings in potentially other zones or other locations?
Yeah, so like, the Olive Street apartments, like the setback is, what, 5 feet? And
Zero?
Yeah, 0.
0.
Like 0.
Oh, okay, 0. Okay, how about Capstone?
0.
0. Okay, so, and so these are going to be these are going to be 0 too?
For the most part.
I think that's right.
So that would be an example where we can come back with
Yes.
more thoughtful information. I'd
Okay.
like to take a moment to, more than a moment, to analyze the individual sub-districts. There is, for example, we are removing setbacks that exist in the current code for residential uses along Fifth. There are, and so where they're currently required to be a minimum of 3 feet and a maximum of 8 feet back provides a little additional space for those. We're lifting that in the draft code. So I would like to hone in on some of those key areas so you don't have to find the needle in the haystack. And
That would be great. I'd
we
appreciate.
can bring that back to you.
Okay.
And if I may, just briefly, if the nature of your concern is the relationship of the building to the sidewalk, that would be one thing to clarify. Also, the relationship of the building to the street depends also on what's happening between within that zone, how wide the sidewalk is, whether there's a furniture zone, whether there's on-street parking. All those kinds of things affect that pedestrian environment, which is maybe kind of.
Right, that's, I think, what I'm looking for, because like, I think in, other urban environments where you have a downtown area that is also welcoming to the environment, the buildings have some type of landscaping or, something that fronts the building. And I don't know if that is a designer choice or if that was a code design, right? So, I'm looking to see what we're getting at with the code, because, after that, then the developer has the flexibility, and I know we have a great developer, and, obviously, he just showed us he's being thoughtful in these regards, but, if it's not in the code, then the developer has a lot of leeway. So I'm just thinking, for me, that's an important thing that I get more information on.
I appreciate that.
Yeah.
I think that excuse me, the other thing that we can add into that is talking about the street sections and how those participate in that urban experience.
That would be really helpful. Thank you.
Okay, I put myself in the queue, and then I'm going to get back to Commissioner Ramey. So I had 4 areas in the code that I would like to have information brought back for the deliberation. The first one has to do with the stormwater treatment. There was significant changes to the stormwater mitigation plans, and so if somebody could be there and explain to me that this is going to be, somebody from Public Works hopefully could come and explain that, yes, this is going to mitigate the stormwater from this property as good or better than what was in the plan before, because it is so close and adjacent to the river that's an important part for me, and it was pretty complex, so.
If I may, I think it appears as such. I mean, there's a lengthy section of draft code, and I'm no engineer, but my understanding is that the change is fundamentally and specifically to just allow for the sharing of treatment facilities within public rights-of-way. In other words, taking private runoff in a shared facility, if the capacity of the stormwater system is essentially overbuilt to accommodate that. Right now, under the code, that mixing or sharing of public versus private stormwater isn't really allowed. And so each site has to accommodate their own private stormwater treatment facilities. I guess just as a reassurance, it does not lessen in any way the city's requirement for treatment of the stormwater, so it still affords the same protection. It just allows for more of a partnership in terms of designing the infrastructure.
Okay. Next section had to do with parking, believe it or not. We did get some talk on that, and what was it I was going to ask about parking? But one of the things was, as far as curb cuts, there was a change in the section that had to do with curb cuts, and I just wanted to make sure that the proposed changes is consistent with the access management plan that the city has, and if not, if you could tell me what the differences are and the reasons for it. Again, we can get back to that.
Okay.
the third thing that came up that I'm going to need some help getting across is the requirement for open spaces for residential, and the fact that in the proposed code language, balconies and rooftop gardens are considered to apply to the open space requirements. And I just want to know if there's any place else in the city that is allowed, and just kind of how that would work and look. If we're saying that you've got a balcony that is 20 square feet and you're counting that as open space for the whole residential thing, just some more information on that is going to be helpful to me. Again, I haven't seen that anywhere else in the code in the citywide. Is it absolutely necessary in this neighborhood to have that be part of the plan? Again, I haven't seen that before, and so some rationalization as to why that is being put into the code for this building downtown next to the river and not the building that would be across the street from it. That's the last of the kind of threes.
So just briefly, and we will come back with more detailed information. I want to, do a little bit of research on the code, but my understanding currently is that multifamily standards in the code do allow for some portion of required open space to be what you might consider private or semi-private within the confines of the development, not what you might think of as a traditional landscaped open space area at ground level. And then we did grapple with this policy choice in the original adoption package in 2013 in looking at this as a desirable place for a more dense urban form of development. And so that was a conversation around this table with the Planning Commission at the time to get to the place where we would allow for these types of open spaces to count more than they would in other areas.
Okay, great. All right, Commissioner Ramey.
Okay. I have a couple of, it's kind of broad-based general questions. What I'm looking at, obviously this has already been adopted once. It's an elaborate development, and it went what appeared to be, although I didn't follow it closely, an appropriate sort of outreach process and design process, and all the right steps. So I don't feel any need to reinvent the wheel if that already happened. And so for the parts of this that are the same as they were before, I don't really think that I need to go back. Although I realize that's our purview to do that, I'm just not sure that would be a great way to use our time. So with that, I'm particularly interested in the changes. How is this different from what was done before? And Gabe, I know you've mentioned a couple things. What I'm really looking for is kind of the high level. I think street layout, heights, and I believe uses. Uses have changed where they're allowed and where they're not allowed.
Well, actually, one of the areas of least change, I would argue, is the use list.
Okay.
And remember, this is what I would consider a hybrid form-based code, where a more pure form, a form-based code wouldn't even dictate specific uses, but through the original adoption process, we looked at certain limitations in terms of uses and really careful look at the types of uses that would help activate the street front at the ground level. And so we did look at that and made a few small changes to respond to some concerns about that and perhaps loosen the reins a little bit in terms of allowing office uses on the ground floor, things like that. So, but yeah, I think you've covered it well as far as the kind of the fundamental changes, the street design, height districts, and individual limits within those, and the park design. Mm-hmm. Yeah, that's another significant one. Yep.
So then, having said that, what I'm struck by is the change in the access or the amount of commercial uses. And maybe I'm just not understanding how the code's written based on what you just said. There's a multi-use zone that's sort of everywhere. And then there's the 1 and the 2. And maybe you could just walk me through how those three, or maybe we don't need to do it today, but we could do that at
Well,
some point in the future.
It might be helpful just as, to give a little primer on that, just so that as you look at this, and again, we've provided you with what I call a legislative format, so you
very
can see really precisely what changed and what it changed from and to. But in terms of the use list, I think it's important to recognize this is different than our other zones in the way that it, I think, very generously allows for the mixing of uses as compared to a commercial zone or a residential zone.
It's that 1 and 2 distinction that, if you could just walk me through how that works.
Right, so the sub-districts, overlays, whatever you want to call them, the MU1 and the MU2 have special limitations associated with them that are primarily, I would say the intent of those is primarily to focus on activating the street front, right? So it's about transparency, glazing windows. It's about, I think that relationship to the street more than anything. And so, yeah, there are certain uses that we are either encouraging or disallowing, favoring one or the other, prohibiting, depending on that.
That's what I'm trying to get to, because again, I, as you know, grew up in Eugene, and there are 2 places in Eugene where you can have dinner and look at the river.
Yeah.
2.
Well, I think.
It seems like a great opportunity, and I'm not sure, and I'll just a little bit out of my purview here. I just want to ask the question, could that, if somebody came and said, got a great idea for commercial use in this location, could that happen?
And are you talking about a specific location?
Anywhere that use the river.
Yeah, well, so let's go back to the regulating plan here where you can see where those overlays exist. So the designation of 1, the active overlay.
That's that one that's got the little notch out of it, the state of Nebraska there?
This right here is what we've often among staff referred to as the restaurant parcel.
Right.
So you may recall there was a design built into the code last time and a whole lot of talk about restaurant row as being this series of businesses and, right at the park front along the new Riverfront street. And I think that there was a recognition on the part of the developer and other folks, and just looking at market conditions, realizing that couldn't really be supported. And so I think what we do see, and again, this is a question of what the use list allows in the zoning, which is very generous and sort of, it depends. It could allow for a number of uses in different configurations. That's different than what this particular developer might have specific plans for.
Right.
What we understand is that there's an intent to use this parcel for a restaurant. And that this, for example, is intended, I believe, as a hotel. And that the balance overall has shifted to some degree to more residential uses throughout the remainder of the property. That is to say, with what we understand their intent to be, as opposed to what the zoning would allow. The zoning still allows, very much so, those types of commercial uses.
That's what I'm trying to get to.
Okay.
But there's only one, so the 3 parcels that go to the south there, well, I guess just the 2, because it's team plan.
Yeah.
So as a mixed-use zone, those would still allow other use, the residential, commercial.
Absolutely.
And restaurants.
Which is commercial, I think.
Yeah. Retail, all that,
But those are not, they don't have the 1 designation on them. That's, again, I'm trying to understand why.
The reason.
Because 1 encourages it, so it limits other things, or what, what's the mechanism for how
I think it's important to recognize that there are additional standards that are attached when that overlay exists, and that they are intended to help activate the street front with the assumption that it would look like, feel like, and sort of, the experience would be sort of a Main Street retail feel. Whereas these frontages along Railroad Avenue and facing south are considered less important in terms of that activation, and that the orientation of those, at least with what we understand, will be to front the river and the park. And so, it's partly, I think it's in some ways some design choices that we understand the developer to be making, but more than anything, I want the commission to understand that your decision is based on what the zoning allows and what the use list allows, which doesn't guarantee the particular outcome.
Let me ask it a different way.
Yeah.
So one has not to do with uses, it has to do with design standards?
That's correct.
Okay, so the design standards are different. 1 and 2 have different design standards from not.
That's right. And just, again, without trying to answer so precisely, as you look at this use list, you'll see individual categories that provide examples. So retail sales-oriented uses, and you'll see it's permitted in MU, MU1, MU2. And so if you see, hey, MU1 and MU2 is not listed here, that means it's not allowed.
Not allowed,
Does that help? Okay, all right.
I think one of the other changes, there's, and as you work through it, you'll see there's a few places where there are differences. And so residential uses in MU1 are only above the ground floor.
Right.
And so that's one of the other places where.
That's a limit.
That's a limit.
1 is limited,
Right.
residential on ground floor.
Right.
That one parcel.
Yes.
And 2 has something similar, probably. Okay,
Yep.
got it. That's very helpful.
Commissioner Edwards, do you have any questions that you'd like to jump into?
I really don't. I'm just kind of following, my only question I actually had to do with the couple of exhibits that were mentioned. Commissioner Faragola had said that there was an email that went out today, and I emailed Gabe and asked if maybe I didn't get on that email, but I had no emails come through in my
Yeah.
box today.
Yeah. I'm sorry. We did receive,
No,
we received that, I was handed a copy of it just before the beginning of the hearing, and so, and just please understand, we'll forward that. It doesn't.
Okay. No, that's okay. I just want to make sure that I wasn't missing it in something, so.
Yeah, and that will be the case for, on an ongoing basis as the open record unfolds. We will batch testimony for 2 weeks, essentially, the first open record period, second open record period, so that you will have everything that we get well before deliberations.
Okay.
Okay, perfect.
Second round.
I'm good. I don't have any other questions.
All right, second round. Commissioner Baker.
Yeah, a couple of things to follow up on the issue of 1 and 2. In the old plan, there were a lot more sort of active areas right along the river. And now I see that there's only sort of, now there's only one building that's labeled 1 now. And there's a bunch of areas of buildings that are labeled 2. And they all seem to be along like Fifth Avenue or one of the other streets. And getting to the question about, are there any places to have dinner and look at the river? It does seem like it's pretty limited now in terms of where, obviously, in any of the multi-use, mixed-use zones, you could put whatever you wanted on the ground floor, but it's like we're not encouraging that not to be, a residential block or whatever. I'm just curious, there was a change from the old plan where there was quite a lot of special areas that were set aside for restaurants, ice cream, that sort of thing, even like a roof area you would get out on the roof even. And I don't see anything like that at all in the new plan in terms of the changes, the zone changes. So comment about that. And then the question is related to, we have a railroad here. So obviously there's going to have to be some fence or separation between that and the area, so, so somebody doesn't accidentally walk into the railroad. And I just didn't know how, what the thought was on how that would be handled. Obviously, you're going to still cross High Street. We're not going to put an overpass on High Street probably, or but that section, that long section there, I just didn't know how that would be, treated from a planning standpoint. And then there was a comment about bicycle access on Fifth Avenue and the width of the street maybe not being, again, maybe you'd add a little more right-of-way to make sure you had space for bicycle paths, because it is a main east-west bicycle street, and that would maybe become, the way it is now, you get to the river by zigzagging and going to Fourth, and then sort of going through EWEB's property now, or going up past it and around. And we have a new street there, but I don't know that, and there may be conflicts if there's a lot of people walking on there too, but we do have streets that are like that. 13th of the University has lots of people walking through it as well as bicycles. So, but it means that you have to have a wider street to accommodate, bike parking, and so I'm just wondering about that issue. And I'll stop there for the time being on the second round.
I can respond to all of those if that would be helpful. The comment you made about the commercial space, I would characterize it as to say that instead of, you said something about the previous plan encouraging more retail, and I would say that the previous plan required more retail. And so what this, the redesign that you see in here, the changes of where these subdistricts are, is intended to recognize that just because we desire retail to be in a certain spot doesn't mean that it will necessarily be there. So all of the flexibility is still there. The intent of retail or commercial uses throughout the site, I think, still remains. That if someone would like to build something commercial in one of these locations, it's not inhibited or not restricted. But I think that one of the things that has been a trend in planning over the last decade or so, including the recession and changes in e-commerce and things like that, is the recognition that that mandated retail doesn't always work, and sometimes what you end up with is empty storefronts rather than something that's active. So the new plan, the shift of Fifth Avenue, focuses the whatever activity there is on the site. It prioritizes Fifth Avenue and that connection between downtown and the river, and I think that comes from an understanding that even 1 or 2 blocks of dead space can be a barrier for people who are walking and choosing where they go. And so the idea is you focus the activity on Fifth, and then the park perhaps has a less active experience. It's maybe less of a commercial destination, but that's at with the opportunity to have Fifth be more vibrant, and the park, if it so happens that there is not enough commercial to fully align the park, then the park takes on a different character and it's a more residential feel. But the idea of front doors along the park still creates some level of activity. It's a residential, quieter activity rather than a commercial activity. But where the restaurant parcel is, where that active zone is, and where Fifth Avenue meets the river, truly becomes that opportunity for those things to come together. For the railroad, my understanding of the railroad quiet zone process that the city is going through in Public Works is that that everything from the intersection of High Street all the way down to the intersection at 8th will be fully fenced off per railroad requirements. And so and that would be meeting all of their safety expectations. The quiet zone, the railroad allows us to have a quiet zone if we raise the standard of safety along the corridor, and so that's certainly something that's being looked at to make sure that it's safe to anybody who's walking along the street. They don't accidentally veer into the railroad. Lastly, for the Fifth Avenue, the width of the street and the bicycle access, the only context that I can add to that is that I know that 4th Avenue between High and the river is designated in the TSP as the preferred bicycle connection. And so transportation planning staff has looked at that, and they've preferred to keep preferred to keep 4th Avenue as the bicycle option, partly because it has slightly faster speeds than 5th Avenue would have. 5th Avenue being a place where there's expected to be more people. There's sections of the street where where it is pedestrian only, and so you'll have more pedestrian bicycle conflicts. And so although bicycles are certainly welcome there, and many people will prefer it as a route, the expectation is that it's slower speeds for bicycles because they're being respectful to the people who are walking through there. And so that was the decision not to put something like dedicated bicycle lanes on that connection. I would say it's something similar to bicycle. You mentioned the university. I think that's a really good example. Another one would be the area around Kesey Square. I think many people find that a comfortable and a good bicycle route, but it's actually not quite as fast as some other options. And so 4th becomes the system link, and 5th becomes a good route for people who like it.
If I could add a follow-up, the issue with later, typically uses in these buildings may, very often commercial spaces get remodeled every 15 to 30 years, somewhere in that time frame. The one thing that seems like it might be worth, if worth considering, is the multi-use spaces on the ground floor. For certain uses like restaurants, you usually would like to have higher ceilings. So, but if the building is not built that way, you're never going to get that. Yeah. Whereas if the form-based code,
It's in there. All ground floor needs to be 14 feet unless it's residential.
Okay, I wasn't certain because I didn't read that detailed. So that was my concern.
Yeah.
That some of the other areas would be left off. So I'll leave it with that for the time being. Although I think the problem is 5th Avenue is going to be the preferred route for people going to the university on this side of the river. You're not going to go to 4th Avenue to zigzag around to get to the bike path. That's just the way things work. So if you're going the other direction, if you're going west or over the river, then yeah. But
Mr. Fragla?
I actually have an interest in bicycle connectivity as well. I think that, this development is going to be a great capstone to our city, and it'll be a focal point and a destination. And I'd like to see it have great bicycle connectivity to the rest of the city. And I had thought that, 5th was one of those places that we were going to be connecting to the Whitaker, so that there was like this stream of connectivity to going to the west. And I also know there's been approval for, sheltered bike lanes on High Street that have been delayed. And so I'm curious what the connectivity of bike lanes is going to be down High Street, because, in my mind, those two coming together really bring the city and the community into this focal point.
I do appreciate that, and seeing how this connects to its surroundings is important, but I also want to recognize something that I've heard from our counterparts in Public Works who aren't here to speak to it. We are not making regulatory changes or asking you to make a recommendation on infrastructure improvements or changes related to High Street or 4th Avenue. Not that it's, unimportant, but I think just recognizing the boundaries of where the commission's role is, it's a very important element of how this connects to the rest of the community, and I want to provide that information. So at deliberations, I will ask to have Public Works staff here to help provide that context. But in terms of our reach for regulatory changes, I think it might be outside the scope.
Okay, I put myself back in the queue, and since bicycles have been brought up, so I kind of did like Commissioner Ramey did. I went through and looked at the code and the legislative changes, and I looked for ones that were significant. There's some that are small, and then there's some that are significant. So one of the ones that jumped out to me as being significant was the bicycle parking requirements. And in the residential, it went from 90% long-term and 10% short-term to just the opposite, 10% and 90%. And let me finish my question before you answer it. So I don't have a problem with that. I think that what I'm hoping is that the developer has come to us and said that, and the reason that they said that was, it says a maximum of 2 in-unit bicycle parking spaces per individual dwelling can be used to meet the maximum long-term. So, and I see why that happened. Okay, we're going to put the long-term bikes in the units. That makes sense. So what my question is, and this might be from the developer, have you used that model before, and is it a successful model? And if it is, that I'm great with that. On the other hand, if that is a successful model and it works in Portland or in other buildings that have, you can show that it works to do that, is that something that should be thought of citywide? Because that is a requirement that we talked about. You know, we've done several work sessions on bike parking, and we said this is the standard that we're looking for. And now we're saying we've got real world data from a person who's building buildings that says this model works better than building a bunch of long-term parking spaces down that are not being utilized. So again, I just want more information possibly from the developer in the open record session, saying why this would be appropriate for this area. And if so, going forward, next time we have the talk on bicycle parking standards for the citywide, put that in as well. So that's one of my thoughts. Now you can answer.
If I may, apologies for jumping in too quick. What we recognized in looking at the 10% and 90% ratio in the existing special area zone is that we made a mistake. It was flipped.
Okay.
And consistent with, by comparing it to other examples in the code, existing code that apply citywide, we recognize that actually for residential, the predominant percentage of bike parking needs to be long-term, not short-term.
Okay.
And so I just wanted you to understand that sooner rather than later in terms of, but I do think it's a great idea to have more information from the developer about what is successful and, their interest in having an allowance that doesn't exist in the code currently to count in-unit spaces.
Great.
Yeah.
Thank you.
Thank you.
Commissioner Ramey.
Okay, I'm going to try to do better. I'm going to try to make these and sort of bring us back more information rather than dial it. Maybe. We'll see how that goes. Then we can get out of here 20 minutes. So there's an alternative path review process for if you want to vary some of the development standards, right? So you can do what it says, or you can go through this alternative path.
That's
design
correct.
review.
Yes, design review.
So when I get to the part of the code where it says, here's the criteria to be used when the design review is being used, how did those compare to what we had before?
No.
I can see what we have now, and I don't see what we had before. And the other sort of subnote to this is typically in that section, in my experience, which is limited, you would find what Commissioner Fregula was looking at earlier, is what is the form-based code trying to do? Is it trying to create a great pedestrian environment? Is it trying to create active storefronts? I mean, there's usually like 4 or 5 things it's trying to do. And if you want to vary what's written in the code and you're going through the special design review section, typically you have to meet those 4 or 5 things, whatever they are. And so I would just, if that's easily found, I found some fragments here and there, but it might be interesting to see how that compares to what we had before and what we have now.
I won't go into great detail, but yes, we can bring back more information on that. that actually has to do with the refinement plan or the, specific area plan that's being repealed and the policies.
Yeah, I was kind of looking for that.
And you don't have that in the draft code, so it's hard to compare. So we'll provide that.
So then I have a series of questions about the Greenway. If I understood it right, I mean, it's slightly different in that where the green, as you mentioned in your opening, it's sort of a blanket approval for everything that happens in this district, as long as it happens in the way it's laid out in something. And I guess finish that sentence is what I'm trying to figure out.
And I would say, so long as it is developed consistent with the downtown Riverfront special area zone, not the concept plan.
Not the concept plan.
But the more precise regulations within the SDR zone. So, in other words, the streets as laid out here, if they're built consistent with the designs embedded in the code, if the buildings are constructed consistent with the height standards and other overlay standards, if the park is developed consistent with the diagram that's in the code and the related standards, it does not need its own additional Greenway permit.
Got it. So then the Greenway permit stops just at the end of this parcel.
No, in fact, the Greenway permit includes everything in color on that diagram. So it extends to include a conceptual depiction of the roundabout, and what I would say is, additional property that is regulated for park uses.
I couldn't find that in the drawings.
Okay.
And I guess at least of my second, since you said roundabout, you're also not going to find the roundabout in, oh, it is right here. But it's not in the subdivision because it's not part of that.
That's correct.
So this is it? This is the only place it would?
It's the only place in the draft code that it's depicted, I think partly because it is very much a conceptual design, partly because it involves a number of unknown factors related to the railroad quiet zone, answers that we don't have yet. But I don't know, Will, or if others, and again, Public Works staff can come back with more information about that as part of deliberations.
I think what I'm interested in is how we're providing public access from the railroad boulevard through and through the park to the path. Right now, it looks like it's coming from a public easement from two different lots. And there's that easement is 14 feet wide, but it says that the view of corridor has to be 40 feet wide. So some inconsistencies in how it looks like to me how we're connecting those things.
Right. So
right there. Yeah.
Yeah. So if you're talking about these specific locations, and we can talk more about this at deliberations, but we have ensured through the subdivision plat that we're establishing public access easements for what will meet our multi-use pathway requirements. They will be constructed to provide a connection to the Riverfront bike path system. They will remain public. And yes, there is a wider swath that's basically the width of the rights-of-way for those two local roads for purposes of unobstructed views drawing you toward the river.
So my question, and again, if you could research and get back to us on this, is why wouldn't those just be rights-of-way that are 14, like an alley? Why wouldn't you just dedicate that as a right-of-way? Because that assures public access through there, rather than a public access easement. And a stranger question about, it's confusing to me with the Greenway because you're not actually building those access points. But the Greenway permit allows them to happen, but doesn't assure that they will happen, because they'll happen over time as
Which access points?
well, the access points at the end of the stubs.
Right. So my understanding is that those are proposed to be constructed as part of the city's infrastructure development that would happen
So that's
following.
LID, it's already funded and.
It's part of the park construction project. So if you look at the green line, I mean, there'll be some that are not in the park, but just outside of that green line, we'll be making those connections, and those connections will be critical to get to overlooks and.
Let me go to the park diagram if it helps to see it a little.
Yeah, that's helpful.
On the right there. So that's the part that's approved with the Greenway,
Yes.
that diagram.
And the sub-area for the park, what we call the cultural landscape overlay.
That's part of my point. There's no little dotted line that goes from the right-of-way across to there,
Got it.
and that, on that diagram.
Mm-hmm.
But we do believe, and I think it's safe to say, we have assured the public's right to access that with a multi-use path connection through there, and you would see that on the tentative subdivision plat. So you'll see that detail.
And why is that not just a right-of-way, I guess?
Fair question.
And then, did I do it? I think I, just a second. Oh, yes, the last thing. The temporary parking provision refers to a map that the 9.3160 parentheses 1 SD-S-D-R Zone Street Network, where I think it implies that those were shown, where, I mean, I can't tell because I don't have that.
So if you look here at the comparison of the street network diagram, on the left, you'll see interim parking areas
That's what those
defined.
little boxes are?
Yes.
So then some discussion about why we're not using the little boxes anymore.
And I would speak generally to that. There's been an interest and a recognition that through the multi-year construction process, and we've actually had testimony about concerns related to parking and the, limitations downtown. There was an interest in expanding the allowance for interim parking areas. So the idea would be that more of the area could be used for purposes of getting through the construction process, or for that matter, for special events related to 2021 games, or whatever whatever the purpose might be, without having to improve it to the full standard with stormwater treatment and landscaping, knowing that its intent is to be developed with a mixed-use building, but in the meantime, it could be parking.
My concern is that, and again, I was not trying to reinvent the wheel. That's why I was asking you where it was, because if somebody said this is okay 3 years ago, then it's changed. But my concern has to do with water quality. And that's why I'm always concerned about temporary things, in particular parking, because there's a lot of sort of things that come with parking that we don't necessarily want in the water. And the water is right there. So this seems to be more heightened area of concern to me, that could somehow leach into I know it's a brownfield already, so what could we do worse, and it's already down, but if those little boxes move closer to the river, then the possibility of that kind of spill or something happening becomes, I think, more troublesome. That's it.
Thank you. Commissioner Baker.
I just had just a question, clarification. There's a clause in, let's see, it's S-DR-MU.
Can you provide a code citation for us?
Yeah, 9.3180. It's under 2, and it's number 7. So it says building ground floor height. For all uses other than residential, the ground floor height shall be a minimum of 14 feet measured from the floor to floor. So are there zones that are strictly residential? Or if you decide to build a residential building in a...
I'm sorry. It's specific to uses. So while the mixed-use zoning allows for any number of uses, it might be retail, it might be office, it might, there's actually some manufacturing uses allowed. For anything other than residential, it has to have the 14-foot ground floor height.
So that was my concern because of later reuse of the buildings. In other words, if a building is built residential, you're not likely to be able to repurpose the first floor to other uses because of this. Floor to ceiling height may be substantially lower.
Well, for example, one of the areas is designated as low-income housing, or is proposed to be affordable housing. So that one's going to be.
But it's uses. So any building that's built all residential would not have to have a high first floor height.
Yes.
I just wanted to clarify that I didn't miss something.
No, you're correct about that.
Okay.
Okay.
And one other question too. There were sections in the old plan, and there are some sections crossed out about sort of view corridors and plantings that wouldn't block the view corridors. So I'm told that some of that stuff has been replaced by other things. Is that in a park plan, or is it in landscaping plans for the street? Because we don't have any street plans for this area. Where would that where would those sort of view sheds to the butte be maintained? In some other plan, which we're not looking at today, I guess, but that's what I'm curious about.
So as far as the streetscape is concerned, do we have standard street sections in here?
We have sections.
Yeah, we have some street sections. But as far as the park is concerned, we're definitely designing to maintain those view corridors. So we have critical, at the ends of these view corridors, we have overlooks over the river to the degree that we've been able to sort of figure it out with utilities and things. But yes, sort of at 5th and then just north of the steam plant, those two. And then the one in the middle, we also have an overlook. It just doesn't reach quite as far out over the river. But those are critical areas where we'll be opening vegetation or we're laying back the bank so you can really get those views to the river and maintain those views through to the development, right? So that was a fundamental tenet of the original master plan, was to bring the river to the city and the city to the river. So keeping those corridors open and drawing people out, through them out to this beautiful river view is one of the most baseline design components that we've incorporated in our park design. I think the other thing I'll add a little bit around activation, just to go back to your questions around sort of active uses, Commissioner Baker. I think one key piece is the steam plant, and that, while that's not like sort of in the code deliberations right now, I think that the plans that we're seeing coming forward for that project are very much, envisioning an active and public space at the steam plant. And so then we'd sort of have, potentially have bookends there with the other active uses at 5th Avenue. So, and then the other piece is around the Park Plaza and the development of that plaza. And, to a greater degree, what people have really asked for and what we've done in our preliminary design work is envision that space as highly active, highly programmable, highly, really a family draw with a lot of, with playgrounds and market booth spaces and, really is a highly active urban park so that, regardless of what the uses end up being around it, because we can't really assure that, the design of the park is really taking those kinds of active uses and wanting to be outdoors into consideration. So that's just, I don't know how critical that is to your code deliberations, specific code deliberations, but I think it does provide some context for within which you might think about some of these issues.
Okay. So we're getting close to time. I did have one more comment that I'd like to make. So again, for me, I'm looking at code before and code after, and knowing that this is a site-specific code request that was initiated by council. And I go back to one that we did just recently with the Edison School. Edison School, the parking requirements wouldn't have made it possible to build a school and have a grassy area for playground. So that made it, okay, we need to do a specific code change for that. And I'm looking at this one in that same thing. And the question that I have, that I keep coming back to is, we've designed things citywide. The Planning Commission and our community has done things citywide and says, we want these criteria in our code. And now what we're being asked is, in this specific area, we can't do the vision that we have because of these specific areas of code. And so my quandary is on things like parking or surface parking and what's allowed. So in every other area of the city, if you want to have surface parking, we've decided it needs to come from the back and you don't want it on the frontage and stuff like that. So for me, having the answers to why this specific zone has to have these changes is important for me. at Edison School, it was clear as day. If the code were implemented, they have no playground. So for me here, if I build a building outside of this zone, I've got to put my parking lot in the back. Tell me why in this zone, if I build a parking lot, it doesn't have to be in the back. And if that reason is justified to me as a planning commissioner, I can move that forward. And so those are the questions that it has to be, okay, this is why I can't build my parking lot in the back. And this is why the bike parking standards are different. And this is why the open space things can be met with a balcony. And if I can answer that as clearly as I was, at Edison School, you're not going to have a playground, I can buy into it. But if it's just because it will make it easier for me to build this building and more it'll pencil out better for me, well, why doesn't it, do I have to do that? Are we going to be doing parcel-specific code changes throughout the city? Because fairness is important to me. And if it's right and it makes sense, I can buy into it. But if it's just because it's easier, I don't know. So that's just kind of some of the things that I'm going to be looking for in deliberation. We are at 7:30. There are a few more procedural things that we need to cover here. Commissioner Edwards, you haven't jumped in. I'm going to give you one more opportunity here.
Thank you. No, I just want to echo what you said. I think that for me, it's helpful to have the context of why we're with specific things, some more information around why it didn't work the way it was previously zoned or whatnot is helpful to understand, like, okay, well, why didn't it work and why are we needing to change it this way in order for it to work? I mean, I do understand things like, moving the main road so that we're not, it provides different access and it's not close to the river, and I understand that, and that makes sense. But so I think in general, it would be helpful just to kind of have some more context around the why for the variations from the way that it was previously laid out to what we're looking to change. So that's really only my only comment.
Okay. So there was an email that came in requesting to keep the record open. Lauren, would you like to talk us through the procedure on this so that we can do it correctly?
Sure, I'd be happy to. So our default open record period is usually a 777 situation where the first open record period is open to anyone to submit any testimony that they feel is relevant. The second open record period is specifically for folks to respond to testimony submitted in the first open record period. And then the third is for the applicant to have a final rebuttal period. And that's required by state law. I was just sort of looking at dates during the course of the hearing, and there's plenty of time to do a 777 open record period. I would look to staff as to whether it would make sense and work for the things that you need to get done before deliberations to think about the possibility of maybe a 10-day initial open record period to give everyone a little bit longer time, a 7-day rebuttal, and then a 7-day final applicant rebuttal. That would put us at May 17th for the first open record, May 24th for the second, and May 31st for the rebuttal. That is, I think, closer in time than staff would usually go to deliberations, but given that we are the applicant, I didn't know.
Well, I think we have some latitude there. I think part of the concern I would express is our ability to not just package and provide it. It'd be a relatively short period of time before your meeting, so you wouldn't be receiving it, for example, all of it anyway, a week in advance. That said, if it works for the commission, understanding that you may be receiving materials, nearer to the date of deliberations, that can work.
And I'm not advocating for that necessarily. I was just
Yeah.
sort of thinking about options.
I think it'll work.
And for me, I mean, we had two people testify, and we had 2 pieces of testimony. I mean, I don't know if there's going to be a ton more. For me, I think 777 would work.
Yeah, I think it's also important to recognize that with the city being essentially the applicant,
Right.
you know, I can't really say with confidence whether we would have a, quote, rebuttal, but we would have the opportunity to respond to what has been submitted. And I think of it as, you know, as your staff providing helpful information in response to what did we get, and, you know, what does it mean, how does it relate? So having that week for that context is helpful, and a little bit of leeway, a little bit of time in advance of the June 3rd meeting. So
I'm looking to the commission here. One, do we want to leave the record open, or do we have to? We have to, okay. So then I think it would be appropriate to entertain a motion for a amount of time to leave the record open.
So we're looking at either 1077 or 777?
Yeah, I mean, those are my,
And where did the 1077 get us to again?
so let me start with the 777.
Yeah.
So 777, by my calculations, anyone can jump in if they think I'm mistaken, would be, the first open record would be open from the close of the public hearing through 5 p.m. on May 14th. Then the second period would be from 5:01 on May 14th to 5 p.m. May 21st. And the third, the applicant rebuttal period would be 5:01 May 21st to 5 p.m. May 28th. And then you're scheduled for deliberations June 3rd.
I guess I'd like to make a motion that we proceed with the 777, simply because otherwise we're pushing up to it basically being the weekend that staff might be working, and since we're deliberating on the 3rd and the 4th, I would love to have information so I can look at it over the weekend, so.
Okay, is there a second to that motion?
Second.
I second.
3 seconds.
I was going to,
And discussion on the motion.
yeah, I was going to, it's really up to the city, so, because we could have like a 774 or something like that. In other words, it's really up to the city because you're the.
that's right. Yeah, we could, I mean, as applicant, we can waive the final 7 days and
can
give
waive the
ourselves time to respond to what
Yeah.
came in, and
we
we
could
may
just-
very well do that.
We could just do a 10-7 and then be done.
Well, I think the city needs to preserve its right to provide a final response.
Okay.
And again, just before you, just for clarity, and for the audience out there, for folks who might be interested in submitting things, during each of those periods, I want to be clear, the first open record is open to all parties. New evidence is allowed, testimony of any kind, really. The second period only allows for responsive testimony. So it's not an opportunity to, you know, a second week to just submit something like a totally new issue on new evidence on a new issue. New or evidence that is responsive to what came in, or testimony that's responding to what came in that first week is, you know, there are limits to what's allowed in that second period, just so folks know. It's not a free-for-all.
And then the last point that I'd like to make is that this is not the final opportunity for the public to weigh in. There's this whole process will be repeated in front of the city council. So there'll be a public hearing, open record. Chances are there'll be an open record section for that, and chance for that moving forward. So there's a motion on the floor. Any other discussion to it? All right, all those in favor? 4 to Commissioner, 5, okay. All right, any other business that we need to do before I close the public hearing? All right, I'm going to close, yes.
Oh, yeah, close, yeah.
I'm going to close the public hearing. And then,
Well, no, you can't. Can you, you can,
The hearing is closed.
Hearing.
The record
The
will
record is
remain
left open.
open
Right.
for written submission only. Yep.
okay. Anything else from commission or staff at this point?
Nothing from staff?
All right, then I will close Commissioner Baker.
Yeah, the Historic Review Board is sponsoring 2 talks in May as part of Historic Preservation Month at the library. One of them is on May 19th. I think that's a Sunday at 2 p.m. It'll be on the Agripac Cannery. Before it was demolished, Agripac was the last cannery in Eugene. Built, was there for 100 years or so. And before it was demolished, the city got a grant to document it, and they put out a bid in the Emerald Photographic Society, the local group, documented it. And it's sort of an interesting story, because Chiquita Bananas owned it at that point and didn't really want it documented, so they sort of did all they could to prevent it. And then there's another talk, these are all at the library. There's another talk on May 30th at 6 p.m., and it's on the now the Amtrak station, which was Southern. There's only 6 masonry train stations that Southern Pacific built that are still standing between Portland and San Diego, and Eugene is one of those. So again, before it was remodeled, the city purchased the building from Southern Pacific, and then before it was remodeled, they had another crew go in, the same actually crew, Emerald Photographic Society won the contract, and they went and documented the building before it was remodeled. So that was, I think, 2004. So, and that's on Thursday, May 30th at 6 p.m. in the library.
Thank you. All right, we are adjourned.